Let's cheat. Let's look forward in time. First speed check, 1.25. Yeah, he's still there. We'll see him tomorrow. We're going to get through this video today and part of this video. And then the other part, and that is tomorrow. And that's the end of May 30th. So I can't see who's on the stand here. I'm just thinking. I'm deep in thought. But someone new is here. So that's June 6th, though. I know June is when the A team comes back and the defense starts their spiel. But that doesn't make sense, though, guys. Something's wrong. Because the prosecution had like 45 witnesses or 56 witnesses, and we're only at number like 40 something. So I mean, at the minimum, the prosecution still has like minimum 6 witnesses left to go, minimum. And this is June 14th, same guy, has to be the prosecution's, it has to be. Unless there's just like a couple quick ones at the end. No, because look, this guy's on the stand here and here. Is that still him? Is that still him down at June 30th? Alright, see this picture right here? Is that guy? That guy? Oh, it's hard to tell. I don't get it. That's definitely a new witness. Okay, that's two quick witnesses. But that's in July. That's 3 quick witnesses right there in July. I don't know. I guess we'll just have to press play and see. Oh, we went down. We went way forward in time. We're not even close. Here we go. Human. Human. Is that better? Because I had my microphone way over there. And now it's right here, right in my face.
Using the yield gel and the slot blot together, one can come to a conclusion as to how much bacterial DNA is in a sample versus human DNA, correct?
Once again, if you assume that the person did a phenylchloroform extraction to begin with, which that's not the procedure we use, once again, we do the Chelex extraction.
You're saying that, in your opinion, it is impossible to do a yield gel while doing Chelex extractions.
Actually, this takes the testimony's argument as sustained.
Can you do a yield gel when doing Chelex extractions?
You can, but it's not going to give you information.
So you can do a yield gel and you can do a slot blot when doing Chelex extractions, correct?
Actually, it's irrelevant. It's argument.
Oral.
Okay, once again, Chelex extractions yields somewhat of a different type of extraction product. And because it actually, to a certain extent, chops the DNA up into smaller pieces, but pieces that are not too small for the PCR amplification process. And it also delivers DNA in a state that's what we call single-stranded. In other words, it's not together in the two-stranded form which the phenol chloroform extract yields. And it's because of this that you can do a yield gel, of course, on a Chelex extraction, but it doesn't give you any information like the phenol chloroform extract would give you if you did a yield gel on that.
You finished?
Yes.
All right. So you can do a yield gel while still doing Chelex extractions, yes or no?
Sustained. Let's move on.
You have section 15 of your protocol deals with yield gels, does it not?
I'd have to see that.
While you're looking at it, can you tell us if in section 15 of your protocol concerning yield gels, it indicates anywhere that it shouldn't or cannot be done when you're doing Chelex extractions? Does it say that?
It doesn't address that point there. It's only a protocol to explain how to do the yield gel.
And section 16 explains how to do a slot block.
Yes.
And you're telling this jury that in terms of doing Chelex extractions, you have no means, which one? In doing Chelex extractions, you don't have the ability to do a yield gel and a slot blot together to determine whether or not a sample is degraded because it has a lot of comparatively more bacterial DNA than human DNA. Is that what you're saying?
It's argumentative and misstates the testimony, Your Honor.
Sustained.
Is it your testimony, sir, when doing Chelex extractions, that one cannot do a yield gel and a slot blot together to get a measure of whether or not a sample is degraded with bacterial contamination?
Objections, argumentative and misstates the testimony.
Overruled.
You can't run a yield gel and get the information that you're referring to.
Now, so you don't know, and in these external proficiency tests that you didn't even run slot blots.
Wasn't necessary. There's typable results. If there was a reason why, I would definitely go back and troubleshoot it by using a yield gel. The extracts aren't going away. They're still there.
Now, in these external proficiency tests you did before working on this case, did it involve blood stains that were mixtures involving two or more contributors?
Wednesday.
I don't ever recall
It's
having to
Wednesday.
take any of my proficiency tests.
So that
The
would,
blood stains.
that would cover proficiency tests before you did work on this case and after you did work on this case.
Yes.
But this case involves blood stains with mixtures, according to the prosecution theory, of two or more people.
Sustained. Rephrase the question.
Does this case, in your opinion, sir, involve blood stains that are mixtures of two or more contributors?
I did some typing that reflected a mixture, yes.
Show. Defense Exhibit 1159H.
Mr. Scheck.
Now, Mr. Yamauchi, is it part of your training that an analyst should systematically change or wash gloves between examining or cutting different items of evidence?
Well, if you're cutting swatches, it's really not necessary because you're not touching the swatches with your gloves.
Your Honor, I move to strike. The answer is not responsive. I asked him a specific question. Is it part of your training that an analyst should systematically change or wash gloves between examining or cutting different items of evidence?
Sustained. Rephrase the question.
Is it part of your training that an analyst should systematically change gloves between cutting different items of evidence?
No,
Is that in your protocol?
I'm not aware of it.
You did not systematically change or wash gloves between cutting different items of evidence in this case, did you?
Overruled.
Once again, I change my gloves when it's necessary. If I'm dealing with swatches, and I believe I explained this earlier, I use a sterile scalpel blade to do my manipulations.
Your Honor, I'd move to strike this as not responsive.
Overruled.
May he
No.
finish his answer?
No, you can ask the next question. Proceed.
Do you feel that routinely changing gloves between each item of evidence that you cut takes too much time?
Overruled.
I just don't think it's necessary.
Do you feel that changing your gloves as a matter of routine between cutting different items of evidence would lower the risk of cross-contamination?
Well, if you're touching the evidence item with your gloves, then yes, that's a very good point taken. But if your gloves are not coming in contact with the item of evidence, it's not necessary.
Now, you helped design boards that were presented in this case concerning the methods used for drying swatches.
For one thing, I didn't help design any boards.
Were you consulted in the construction of boards that were introduced through Dennis Fung and Andrea Mazzola in evidence in this case concerning the drying method using test tubes? Were you consulted when those boards were put together?
Objections beyond the scope of direct.
Sustained.
Is changing of gloves between handling wet swatches during the drying process something you believe necessary?
Well, once again, if you're handling, you mean the gloves physically coming in contact with the swatch itself?
Are you familiar with the method used in this case by Mr. Fung and Ms. Mazzola to dry the swatches by taking wet swatches out of plastic bags, placing them in test tubes?
Beyond the scope of direct.
Sustained.
Did you, Aaron Riley, or anyone else from the DNA unit give a lecture to the criminalists that collect, dry, and package the evidence, such as Mr. Fung and Ms. Mazzola, telling them that it was critical to systematically alternate substrate controls when handling swatches in the evidence processing room because such controls could later be used as a check against cross-contamination in DNA testing?
Objection, it's compound, may call for hearsay, Your Honor.
It's compound.
Did you or Aaron Riley or anyone from the DNA unit give lectures to the criminalists, specifically Dennis Fung and Andrea Mazzola, about how to handle swatches in the evidence processing room which were going to be subjected to DNA testing?
Compound, may call for hearsay.
Overruled.
Well, I personally haven't lectured them. Aaron Riley may have talked to them about that. I don't know.
In the course of setting up your DNA laboratory, was there any discussion that there should be a uniform method among all the criminalists for handling blood swatches to minimize the risk of cross-contamination?
Objection, call for hearsay.
Overruled.
Also speculation, no foundation.
Overruled. Was there any such discussion?
With Dennis and Andrea, no.
No. First question, was there any discussion among you in the DNA unit that it would be important to have one uniform way for handling wet swatches for purposes of minimizing the risks of cross-contamination in DNA testing?
Objection, beyond the scope.
Overruled.
Discussion of one uniform way. No, I'd have to say no.
Now, I'm looking for the board now that concerns cutting the swatches.
All right, while we're waiting, looking for that exhibit, if anybody needs to take a comfort break.
Joshua won't let me pick him up.
Waiting for him to return.
It's really annoying. Joshua gets his own personality like that. That's just rude.
All right, why don't you wait till we have all of our hearers?
I'm gonna go get Joshua. Oh, there goes my microphone again. I'm gonna go get Joshua. I'm gonna go get Joshua and see if he'll let me pick him up today. Yep. I just gotta fast forward this quick. Wow, this is a long comfort break.
All right, we have our full complement of jurors. Mr. Scheck, which exhibit is this?
This is, 277.
All right, Pecos 277. Proceed.
Now, Mr. Yamauchi, this is the evidence sampling board, is it not?
Yes, that's what it's described as on top.
Did you have any part in putting this board together?
Well, at the DA's request, I was asked to be in some photographs, and they put it together.
You mean you didn't give them any advice on how this ought to look based on what you actually did in cutting the swatches in this case?
Objection calls for hearsay, Your Honor.
Sustain.
But you said the DA set it up, right? You just said that,
Yes.
didn't you? Well, before that was set up, didn't you have an extensive discussion with them about exactly what happened before this board was put in place?
Yes, they asked me what I did and how I did it, and they said, let's take some photographs documenting that process. I said, fine.
Mr. Yamauchi, didn't you have a bigger role in setting up boards other than this one?
Objection is irrelevant beyond the scope.
Sustain.
Well, you recall a videotape being made of Andrea Mazzola picking up swatches?
Your Honor, I have an objection.
Sustain. No, sustain. It's irrelevant.
Was a videotape made of this?
No.
Okay. And in this demonstration, you are cutting a plain white swatch, is that correct?
Yes.
You're not cutting a
He
red
doesn't
swatch
care what you
full of
need.
blood, are
He
you?
just doesn't care what you need. He's just gone.
No.
And was that done to minimize the risk that during the course of putting this together, you might accidentally get a little red on your glove?
Objection is argumentative.
Sustain. Rephrase the
Do
question.
you know who made the decision to use a white swatch rather than a
Zach,
red
are you
swatch?
screwing with me right now? Are you just trolling me right now? Zach, I don't think you understand. This house is hell right now. I don't think you understand. All right. I rescued Gara. She's gone now. I rescued Gara about, I don't know, a year and a half ago, I'm guessing. It's just a number. And then Gara had babies. And then they had babies. And then my daughter moved in with her cats and they had babies. And we have a lot of freaking cats. It just happened. We had like a couple cats and now we have like a lot of cats. And it's too many cats. And they're everywhere. And we're trying to get rid of them. Slowly we're getting rid of these cats. But it's super slow because it's kitten season or whatever. I don't even know what that means. So nobody wants a cat. We have lots of kittens. They're all kittens. So they should be easy to get rid of. But they're not. They're impossible to get rid of. And there's a lot of freaking cats in this house.
About using red swatches, I don't think that issue ever came up. The whole idea was to demonstrate the procedure that I would go through in sampling.
Well, most of the specimens that you cut were red swatches covered with blood.
Yes.
But you're not demonstrating
Not
a
if
red
he doesn't
swatch
let
covered
me
with blood
pet
on
him.
this board, are you?
Yes, I'm just demonstrating the procedure I'd use to cut such a swatch.
And you were aware that other demonstration boards had been put together starting at the beginning of the process where swatches were made with blood on them.
Objection is beyond the scope. Argumentative.
Sustained. Counsel, the board pretty much speaks for itself what it is and what it isn't, so let's not waste a lot of time on this.
Now, are you telling us, sir, that when you went through all the different swatches on the morning of June 14th, that you only used one hand with the scalpel in it to manipulate those swatches?
Yes, that's how I do my sampling.
So, in other words, looking at this board, you have a scalpel that is about how long?
Approximately 1.5 inches.
And when you grip it, about how much of the blade is there that
Come
is
on.
uncovered by your fingers?
Enough. Enough.
I don't grab the blade.
Well, look at number 3 on this Exhibit 277. Does that demonstrate how you held the scalpel when you went about manipulating the swatches?
Yes.
All right. And about how much of the scalpel is exposed as you hold it in your hand? How long an area is that?
Oh, maybe 3/4 of an inch.
And the way you go about cutting these swatches and then putting them
Thank you
in
so
a
much
test tube
for
is
caring about
indicated
cat poop like
on
I
3,
do.
4, and 5 of
Thank
this
you.
evidence sampling board is that you do it with just one hand with that scalpel.
Yes.
You cut it, is that correct? Cut the swatch,
Yes.
and then you stick the scalpel into the swatch, pick it up, and put it into the microfuge tube.
Right, the microcentrifuge tube.
And on the morning of June 14th, when you did the swatches in this case, you did all the swatches with one hand.
Well, this is the same procedure I used. Yes, that's how I do it.
And you don't use forceps or tweezers.
No, I don't.
And you never touch any of the swatches with your glove.
No, I don't.
And you didn't touch any of the swatches with your glove on June 14th.
No.
Now, and you feel there's no danger in this technique of touching a swatch with your glove.
No, I never said anything about touching the swatch in my glove.
Doesn't happen.
I didn't touch the swatches with my glove.
Now, you told us on direct examination that with respect to item 49, you originally counted out 5 swatches.
Yes.
And then you noticed that 2 swatches were stuck together.
Yes.
And then you pulled them apart, didn't you?
Yes.
Are you telling us that you pulled apart those swatches with one hand holding that scalpel and didn't use a forceps and didn't use the tweezers and didn't use your other hand?
Yeah, well, it's not easy, but if you take the scalpel blade, you can get it in between them and kind of jiggle them apart.
And you have a specific recollection that you were able to do that in this case?
Yes.
Incidentally, when you were handling the socks last Friday, were you aware that you were also touching the microphone with your gloved hands and then went down and touched the socks?
I could have, yeah.
Were you aware of it?
Yes.
And so there, as far as you're concerned, there's no possibility that you inadvertently touched the swatches, even when you were pulling apart those 2 swatches that were stuck together on sample 49.
No, I use a scalpel blade.
Now,
Good job, sir. Good answer. Good answer.
Mr. Scheck, 10:45.
Oh, he is super annoyed right now. Super annoyed. He needs a cape.
now, Mr. Yamauchi, please listen carefully to my question. Is it part of your training to change lab paper between cutting different items of biological evidence?
Objection vague.
Okay, if I'm
Part of
working on,
training.
one item that needs to be placed on directly to the lab paper, then yes, of course, I'll change the paper. But if I'm working on clot swatches, what I do is I change the chem wipes that are beneath the bindle, the paper bindle.
So you believe it's important to change paper between handling blood swatches?
The paper immediately underneath the bindle that I'm working on.
Are you aware that in scraping out the blood swatches, in this case, Andrea Mazzola and Dennis Fung did not change the paper between items?
Objection, calls for hearsay beyond the scope.
Sustained.
Did you hear the testimony of Dennis Fung and Andrea Mazzola with respect to how they handled the blood swatches in the evidence processing room on June 14th?
Objection beyond the scope, calls for hearsay.
Sustained.
I take it that it's the beyond the scope objection that you're sustaining. Well, you listened to testimony in this case from your fellow criminalists, didn't you?
Yes?
And did you have any part whatsoever in advising Dennis Fung, Andrea Mazzola, or the prosecutors on how to create the board dealing with drying swatches?
Objection beyond the scope, compound, calls for
This
hearsay.
goes to the issue of paper.
Beyond the scope, calls for hearsay, no foundation.
Overruled.
I didn't have anything to do with making their boards, or that was all through the prosecution. They made their own boards.
So, in your opinion, when handling blood swatches, when you're taking them out of test tubes, one should change the paper.
Well, if the swatches are going to touch the paper, then yes, I would say that that would be a good idea. But if they're not allowing the swatches to touch the paper, then there really isn't any reason to change the paper beneath them. You see my point?
Mr. Yamauchi, I thought you just told us that it was your routine practice to change paper every time that you handled a different blood swatch, except when you had chem wipes underneath the bindles.
Objections, argumentative, misstates his testimony.
Sustained. Rephrase the question.
Did you just tell us that you believed that paper ought to be changed between each evidentiary item, including blood swatches, except in an instance where you're just changing the chem wipes?
Yes, that's what I said, and that had to do with the blood swatches again.
Is it part of your training to clean a table with bleach between cutting different evidentiary items?
No, I'd make sure that there's a barrier between the table and the item, somewhat like fresh paper, but I wouldn't bleach it down every single time.
That's not in your protocol,
Not to my recollection.
and you didn't do it in this case, did you?
No, I didn't.
B. Now, Mr. Yamauchi, in the course of your training, was there discussion that the danger of cross-contamination is greatest when an analyst is dealing with degraded samples?
And I don't recall anything to do with my training specifically stating that.
Your training took 6 months, at least?
At least.
How long was your training period?
Approximately 6 months.
All right. And you took a course at Roche,
Yes.
and you did readings.
Yes.
And you're telling us that in the course of your readings and in the course of the Roche class, there was no discussion that the danger of cross-contamination is greatest when an analyst is dealing with degraded samples.
Objection, call for hearsay, Your Honor.
Overruled.
Those exact words being the greatest source of contamination? No, I don't remember anything like that.
All right, let's try a different phrase. Was there discussion that the risk of cross-contamination was raised when dealing with degraded samples?
No, I don't recall any discussion like that. If you had more information to go along with that, just degraded is not enough for me to make a distinction there.
And in the course of all of your training, there was no discussion of false positives occurring with degraded samples.
No.
On June 14th, you had no idea if the swatches that you were handling from the Bundy scene were degraded.
Well, like I said before, all our casework samples are degraded to a certain degree. How badly? No, there's no way of knowing by looking at a sample what the quantity and quality of DNA is on it.
Right? They look like rich red swatches to you when you were handling them on June 14th.
Well, some of them were red, some of them were light red. They were all different types of shades.
And I think, as you told us already, that it's not your practice to do yield gels.
No, because we do Kelex
All right.
extractions.
But you do allow that you can do a slot blot.
Yes, we could do a slot blot, and that would be used in troubleshooting should something anomalous come up or something that needs to be troubleshooted.
And if you did a slot blot before you proceeded with the extraction of DNA, you would have an idea of how much human DNA within those swatches.
Yes, I would have more information as to that effect.
And if you did a slot blot, that might have given you some information as to whether or not these Bundy samples you were dealing with were degraded.
If I did a slot blot, it would tell me whether or not there was human DNA there, but it doesn't necessarily tell you the state as far as whether it's degraded or not. It can give you a slight idea, but it doesn't address that issue.
Well, if you do a,
Completely.
I'm sorry, you finished?
Yes, I am.
Well, if you do a slot blot and you see that there is less human DNA than you would expect just by eyeballing the swatches, that would give you some information that you were dealing with degraded samples.
I'm sorry, could you ask that question one more time, please?
Sure. If you did a slot blot and the slot blot reading showed less human DNA than you would have expected just looking at the swatches, wouldn't that be an indication that the samples were degraded?
A low amount of human DNA, that statement coming from a slot blot would be an indication that there's a small amount of DNA there.
And on the morning of June 14th, you were operating on the theory that the blood drops at Bundy had been deposited within 12 hours of their collection.
Objection calls for speculation.
Sustained.
Were you operating on the premise on the morning of June 14th that the blood drops at Bundy had been deposited within 12 hours of their collection?
Objection calls for speculation.
Overruled.
Well, we can't really speculate as to how old a stain is. It's just handle all evidence in the same fashion that you would, whether it's possibly there for 12 hours or 24 years. The same procedures and steps are in line.
Mr. Yamauchi, are you telling this jury that you would handle a sample that was 24 years old in exactly the same fashion as you would handle a sample that was 12 hours old as far as you knew?
Yes, I would.
In other words, as far as you're concerned, degradation and the effects of time plays no role in the way that one handles samples.
Well, time doesn't necessarily isn't necessarily the only factor that causes degradation. So we have had good typing results off of samples that are a number of years old, and you always just can't put your money on one thing or another.
Well, let's
So
I'm sorry, you finished?
no, I'm not.
Go right ahead.
Okay, so whether or not you've got a brand new, fresh exemplar or an evidence item, you still have to treat them the same. You can't assume that one's old and or degraded or for whatever reason, because there's too many factors involved for us to know everything about that sample.
Now, Mr. Yamauchi, on the morning of June 14th, you had certain information about this case through Dennis Fung, didn't you?
Yes.
He had a conversation with you in the evidence processing room. You do remember that?
Yes.
You don't remember seeing Detective Lang anywhere on the morning of June 14th, right?
Well, I'm not sure if I saw him that day or not. It just, my memory, it's almost a year ago.
Are you aware of any legal issues that have arisen in the last 2 days that make it important for you to forget that you ever saw or spoke to Detective Lang on the morning of June 14th?
Sustained juries to disregard the implication of that question.
I take it you didn't see Detective Lang anywhere near the evidence processing room or any of the swatches on the morning of June 14th?
No, I don't know.
Now, in a conversation you had on the morning of June 14th with Dennis Fung, he communicated certain things to you that he had learned from the detectives that were investigating this case.
That's what I would assume he got that information from, sure.
Well, didn't he tell you explicitly that he had obtained certain information via or through robbery homicide?
Yeah, he might have said that.
Well, don't your notes specifically say that Dennis Fung told you that Mr. Simpson had a cut on his left hand and he had learned that via robbery homicide? Didn't you write that down?
That sounds familiar, but let me check my notes to be sure.
This will be the last question and answer before we take a break. You want to direct his attention to a page?
You found it, didn't you? Mr. Yamauchi, you have your notes as to the morning of June 14th written out as to the events in the evidence processing room on something called a serology item description sheet, do you not?
Yes.
All right. And on the first page of those notes, there is a description of the Bundy samples.
Yes.
And there's a note in the top part of your page indicating that you learned that Mr. Simpson had cut his left finger on his left hand via robbery homicide, per Dennis Fung.
Yeah, I wrote as per Fung and in parenthesis via RHD. OJ's cut on left hand.
Right. And via RHD means that, that note means, does it not, that Mr. Fung told you that he had learned from the detectives at robbery homicide that Mr. Simpson had a cut in his left hand.
Yes.
One more.
Go ahead.
Did he indicate to you, via the detectives from robbery homicide, that the Rockingham blood drops were expected to be Mr. Simpson's blood?
Overruled.
He indicated there was a blood trail leading away from the scene, and he talked about that cut, and they could possibly be linked.
My question had to do with blood drops from Rockingham. Are you with me? Not Bundy.
Blood drops from Rockingham, okay.
All right. You know which items we're talking about?
Yes.
Did Mr. Fung indicate to you, through information that he got from the detectives at robbery homicide, that they expected that the blood drops at Rockingham would be Mr. Simpson's blood?
Objections made as to during the conversation.
Talking about this morning on June 14th.
Overruled.
Well, I didn't get Rockingham samples till the next day, I believe.
When you were talking with Mr. Fung on the morning of June 14th, did you know that detectives at robbery homicide had taken a statement from Mr. Simpson earlier that day?
Sustained. All right, ladies and gentlemen, we're going to take a recess at this point for 15 minutes. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you. Do not conduct any deliberations until the matter has been submitted to you. We'll be in recess for 15. Back on the record, as soon as I get a court reporter. All right, are we ready to proceed? All right. Yes.
Just before the break, Mr. Scheck posed a question that was so unethical and so improper that I think that the transcript should be sent to the State Bar. I think he should not be permitted to practice pro hoc vice. I find it not only appalling, but I am ashamed as an officer of the court to see this kind of behavior. It was a deliberately improper question that Mr. Scheck knew to be improper, bringing out such information.
Yo, she doesn't want sanctions anymore, guys. She is way, 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 way past sanctions. She wants Scheck disbarred for that question. She's straight to nuclear this morning.
In front of the jury with no appropriate focus other than to give information to the jury which is inappropriate, which cannot be brought out in that manner, in an effort to prejudice the right of the people to a fair trial, in a very inflammatory manner, no less. I think that the sanction should be very severe, and I think that the court should not take this lightly because the court could see this coming. The court knew that Mr. Scheck was going to try and get that in front of the jury. I'm sure that you did. We anticipated it, and then the question, sure enough, was asked. And Mr. Scheck knows it's improper because there is no lawyer with half a brain, with an IQ above 5, who would not have known that such a question is improper. And to deliberately ask such improper questions, such inflammatory questions, deliberately designed to thwart justice, should not be treated lightly. And we are asking the court to impose a sanction, and we are going to draft a proposal for that sanction. I'd like the opportunity to confer further with counsel concerning that. But at the very least, the jury should be ordered to disregard the statement made by Mr. Scheck and should be admonished that Mr. Scheck's conduct was highly inappropriate. And that's just for starters. May I have a moment, Your Honor? Further, Your Honor, at this time, the defense should be ordered not to make any references to that statement. These references to the statement are an effort to hide behind inferences that can be thrown out in front of the jury so that Mr. Simpson never takes the witness stand. This is an effort to hide behind a lawyer's arguments and a lawyer's statements so that he will not have to take the witness stand and face cross-examination. If Mr. Simpson wants to testify, let him do so. As I said before, we welcome the opportunity to hear what he has to say. But to hide behind implications, inferences, and innuendos that are improperly made before this jury is highly inappropriate, unethical, and a deliberate effort to thwart justice and prejudice the right of the people to a fair trial. So no further reference should be allowed by this court to be made to any statement by the defense to the ends that I've indicated, and the jury should be ordered to disregard any statement made thus far and should also be admonished that Mr. Scheck acted in an unethical and improper manner in doing so.
Mr. Scheck?
Your Honor, I don't think there was anything wrong with the question I asked. There is evidence in this record that Mr. Simpson gave a statement. The contents of it are not in the record, and we went down that road. The question I asked Mr. Yamauchi, which is an area which I think I'm entitled to explore and to get his answers under oath, are...
I didn't realize what time it was, guys. I have to go. I'll be back really, really, really soon, okay? Be good. Behave. Try to figure this out for me.
to what extent he has knowledge about information from robbery homicide. Now, I did not ask what I think would be objectionable questions, and that is, are you aware that Mr. Simpson said A, B, C, and D? That I can't ask, but I can ask, and in fact, it's foundational to some more questions that I want to ask him now about, was he aware or did he know that Mr. Simpson made a statement? Did he know it through Dennis Fung? Did he know it through Greg Matheson? Did he know it from listening to news reports? Now, if he says yes, that he was aware of it, then I might be able to go further in terms of what he knew in terms of the door that they opened. I obviously can't say by my questions, were you aware that Mr. Simpson said A, B, C, and D? But I'm allowed to ask whether he was aware that Mr. Simpson made a statement. And the fact is, that we've already had in the record the fact that Mr. Simpson went down and the evidence has been that Detective Van Anner and Detective Lang took a statement from, so the jury knows that. There's even, there was one other incident, as I recall, and the court will recall the details a little better than I am sure, where there was another door opening problem with respect to characterizations of what he did or didn't say with respect to the other detectives. But I believe my question was very careful, and I think I'm allowed. What I want to ask him, actually the witness is here. Maybe he should.
Has nothing to do with what I'm going to rule upon here.
Okay. Well. I wanted to propose further questions along this line that I think I should be entitled to ask as to the state of this witness's knowledge, without getting into the contents.
What's the relevance of that?
What?
What's the relevance of
Well,
that?
as I understood the court's ruling with respect to opening the door, and I'm not sure the witness should be here for this, but a lot of it turned on the extent to which this witness had knowledge of certain information via what sources. The prosecution has elicited hearsay statements with respect to a statement of airtight alibi on their direct examination and deliberately elicited hearsay as to Fung's conversations with Yamauchi and his state of knowledge, which I didn't object to. And it came out. And the reason I didn't object to it is that I want to probe it now. And I think I should be entitled to probe it. Now, I want to probe it in a way, and I think I have done it in a way that's perfectly responsible, where I'm not saying what Mr. Simpson said. I'm not introducing the content. I think I'm perfectly allowed to establish what, if anything, he knew about whether a statement was taken and what other sources of information he had through Dennis Fung about facts that came via robbery homicide. I mean, the court made a ruling at a certain point with respect to door opening that was based on the representations of the prosecutors as to what Mr. Yamauchi would say and what he had said so far on direct. I think I'm allowed to go into the state of his knowledge to see whether or not I can elicit more information that will allow me to go somewhat further. To do it carefully, but I think that under the court's ruling, I'm allowed to do that.
Don't we have a huge 352 problem here, though?
Well, the 352 problem, I don't think applies with respect to information that Mr. Yamauchi would get via the detectives at robbery homicide that would go to the analysis of samples. Now, with respect to whether or not the blood at Rockingham was undisputedly Mr. Simpson's, or whether he had information to that effect without saying that Mr. Simpson said that, is relevant in terms of how the samples were handled and what he knew and whether the samples should have been handled at the same time and the level of DNA content of the samples. It's all relevant. I think I indicated to the court before I was going to go down that road, and that's one of the things that I wanted to explore with this witness. Frankly, that's my next line.
Mr. Couch, your questions in terms of a statement that you cannot bring in through this witness, I think is unduly confusing and time-consuming, isn't it?
Well, before I propose that, could I again ask that Mr. Yamauchi be excused for just a minute if we're going to discuss what he will or will not say?
I hate to take a whole lot of time.
Well, Your Honor.
Mr. Yamauchi, why don't you step outside? Thank you. Mr. Scheck.
Yes. Obviously, this area also goes to the whole issue that they brought up of examiner bias and what the source of his knowledge was and wasn't. They brought it up, not me. And they brought it up earlier in terms of Detective Lang volunteering this. Now, I think I'm allowed to go into, I mean, just because the prosecutors get up and say he didn't know anything except what he heard on television doesn't mean I can't probe it on cross-examination. Frankly, I think it's highly incredible that we have in the notes of Matheson that Yamauchi was present at a meeting between him and Detective Lang, along with Mr. Fung, and that Detective Lang was in the evidence processing room, was in SID that morning, and this man has no recollection of even seeing him. I mean, I think it's perfectly clear that we should be able to explore whether his memory got very convenient about what contact he had with the investigators and what Mr. Fung told him the investigators believed and the basis for the investigators' knowledge. Because to the extent that he has knowledge of that, it goes to the issue of examiner bias, and it goes, frankly, to the issue of how far that door can be opened. I don't see why I'm restricted in cross-examination from exploring those areas when they brought it up, just because they say, oh, we heard it all from news reports, and it doesn't have any, it didn't emanate at all from the police. Why should I be bound by that? I should be able to explore what information he got from the police without explicitly indicating what the content of the statement is.
But you can't do it without bringing in contents of statements if what you suggest is true.
Well, I haven't gone that far yet. All that I have said, and I've been very careful, that's the point. I asked him whether he knew through Mr. Fung or through police that there was a statement. Next question I want to ask him is that he said that he had listened to news media reports. Was he aware that Mr. Simpson had made a statement through news media reports? That's all. I mean, we've all seen the videotapes where Mr. Simpson was taken down to the Parker Center, and there was reports of the statement being made.
We've all seen that. The jury has not seen that.
I understand
At least
that.
not as part of this record.
Well, but what is part of the record is that they had him testify to airtight alibi. Now they get up and say, be assured, none of that information came through detectives at robbery homicide. All of that information came through television news media broadcasts. Well, if that's the case, I think I should be able to ask him if he learned through television news media broadcasts on the evening of June 13th that Mr. Simpson had made a statement. And if he did learn that from television news media broadcasts, why shouldn't I ask him if he inquired of Mr. Fung about that statement and about what the detectives had told him? I mean, I think I should be allowed to go down that line without getting into the content of the statement.
All right, I'm going to sustain the 352 objection to that. I think it's way too overbroad. It takes us down avenues that we don't need to go with this particular witness. You're directed not to ask any further questions regarding statements made by Mr. Simpson. Let's proceed.
Well, Your Honor, then can I make the request that if that's going to be the ruling, that the jury should be instructed to disregard the statement he made about airtight alibi?
I'll tell them that. Let's proceed.
You know, this is in direct derogation to your own order before saying that there was no 356 problem here. What was, the witness specified his state of mind based on a newscast.
Counsel, that should not have been gone into in the first place. I then asked, if you recollect, I asked the defense if they wanted stricken. They indicated they did not. Let's have Mr. Yamauchi. Let's have the jurors. Seated. Let the record reflect that we've been rejoined by all the members of our jury panel. Ladies and gentlemen, before we proceed any further, I'm going to instruct you to disregard any testimony by this witness, Mr. Colin Yamauchi, as it relates to any statements alleged to have been made by Mr. Simpson, either on direct examination or on cross-examination. All right, Mr. Yamauchi, would you return to the witness stand, please? All right, good morning again, Mr. Yamauchi. You're reminded, sir, you are still under oath. Mr. Sheck, you may continue.
59C. Mr. Yamauchi, was it part of your training to avoid cutting evidence items with high DNA content in the same period and in the same location as you're dealing with evidence of low DNA content? Was that part of your training?
Not found yet.
Rephrase the question.
As part of your training, were you given any instruction on how to handle evidence items that might contain high DNA content and low DNA content?
Well, we already went over this. Is you can't really know whether some items have high DNA or low DNA by looking at them. So falling back to my normal standard procedure, I make sure I don't open up an evidence item along with another one. In other words, I only work on one item at a time, so at no time are two items of evidence open simultaneously. And I think that would address your question, because if I don't have two of them open simultaneously, then they wouldn't be done at the same time.
Well, so as far as you're concerned, there are no dangers then of first cutting a sample with high DNA content, putting that aside, and then moving to a sample with low DNA content.
Objections made, argumentative, Ms. Stace's testimony.
Do you understand the question, Mr. Yamauchi?
And I believe I do.
All right, go ahead and answer.
Once again, if I sample an item and I don't know what the content of DNA is in there, irregardless of that, I'll sample that, close it off, and take care of everything with that one sample first. And only then, my sample's encased into one of those microcentrifuge tubes. Only after all that's capped and everything's closed off will I move on to another sample.
All right? And so as far as you're concerned, as long as you go sample number one, then you take sample number two, there's no problem.
Call roll.
Following my procedure where I close everything off, no, I don't see a problem with that.
Now, let's move to the DNA extraction phase and the DNA amplification phase. Are you with me?
Okay.
On those two phases, was it part of your training to avoid analyzing samples with high DNA content and low DNA content in the same series, in the same run of microcentrifuge tubes?
My procedure of only keeping one tube opened at one time and working on one one sample at a time goes through to my handling in the amplification process also. So at no given time do I have 2 tubes open of extract simultaneously. I'll only have one open at each individual time, and I'll pipette from that into the next step. And in that case, those 2 would be open, but one's receiving the sample.
So it was never part of your training to avoid, at the extraction phase or the amplification phase, doing in the same run samples with high DNA content and low DNA content, just in case there was inadvertent cross-contamination. That's not part of your training.
Oh, well, do you understand the question?
Yes. Once again, they're closed off from each other, so there's no way they can contaminate each other.
No way you can make an inadvertent mistake, a mistake you're not aware of.
Sustain. Sustain.
You've received no training to avoid situations with high DNA content and low DNA content samples in analysis to lower the risk of cross-contamination. That's not part of your training.
Once again, the whole procedure by which I sample and do the analyses preclude that from happening because I separate each and everything off from each other.
Is it part of your training not to cut evidence samples from 2 different crime scenes in the same place during the same period of time?
Sustain.
In the evidence processing room, within a half-hour period, taking sample after sample, was it part of your training to avoid cutting samples from different crime scenes in the same series?
Once again, my procedure, I don't allow 2 items of evidence open at the same time. I do them one at a time.
Okay, so since you do the evidence items one at a time, it doesn't matter to you that you'll handle evidence item number 1 from one crime scene, and then you move to evidence item 2 from another crime scene.
It's not happening at the same time.
Well,
I sample everything one by one.
you do a series of 5 items. Are you with me?
Okay.
Item 1 comes from crime scene number 1. You finish with that, then you go to item 2 from crime scene number 2. Go to item 3 from crime scene number 3. Go to item 4 from crime scene number 4. Item 5 from crime scene number 5. No problem with that.
Provided the conditions and the procedure that I use is in effect, where I make sure each item of evidence is closed off from the next one to eliminate chances of cross-contamination, that's fine.
1159F. Your answer would be the same with respect to handling samples from a suspect and a victim in a series.
Yes, my answer is the same, using my protocol and procedure.
1159E. Now, Mr. Yamauchi, let's talk about handling reference samples from a suspect and evidence samples. Do you not agree that a reference sample from a suspect creates a special danger of cross-contamination?
If mishandled, of course it would create a danger, but if it's handled correctly, there's no danger.
Would you agree that reference samples contained highly concentrated amounts of DNA?
They have a good amount of DNA in them.
Well, the blood from a reference sample, you would expect to be much more highly concentrated in terms of its DNA content than the blood swatches that you handled on the morning of June 14th.
How would I know that?
You wouldn't.
You can't tell by, I'm sorry. Can I finish?
I thought you had.
Well,
You asked me, how would you know that? Let me pose another question to you.
okay.
Your Honor, I think he was going to embellish.
Now,
I think, have you completed your answer?
Well, I'd like to add something.
All right, answer the question.
Okay, in terms of looking at swatches you can't tell the quantity or quality of DNA that's on them just by looking at it. It's not scientifically possible to do that kind of assessment. You can give a ballpark guess, but you can't know.
Mr. Yamauchi, is it not fundamental laboratory practice to assume that the blood from the reference sample of a suspect is going to be much more highly concentrated in terms of its DNA than the sample that you'll get from an evidence specimen?
That's not always the case. Sometimes you can get evidence samples that are very concentrated in DNA.
My question to you, sir, is, isn't it fundamental laboratory practice to assume when examining a reference sample and examining an evidence sample that the reference sample is going to have much more highly concentrated DNA?
Oh,
No, I can't assume that. I treat all my samples the same way, the same proper precautions that I explained earlier.
So you make no special exception for handling a suspect's reference sample?
Well, I may take a smaller piece, a smaller cutting.
When handling a vacutainer tube with a defendant's reference sample, there is a danger of aerosols or sprays when the tube is opened.
Well, there is if you just open the cap up, but if you do, as I explained earlier, and put Kim wipes over the top of the cap and carefully open up the cap, any aerosol that could be caused by that would be trapped in the Kim wipe. And in that way, I rest assured that my procedure is good at keeping any such aerosols from contaminating anything else.
And when opening these tubes, there tends to be blood on the caps.
Yes.
And that can present a danger when you handle it of getting blood from the cap on your hands or on other items.
Well, yes, and I keep the cap inside of the wad of Kim wipes.
And when you're handling a reference tube, there's a danger in opening it of spills.
Well, anytime you hold a vial or a glass of liquid, there's a danger of a spill.
And when you're handling these Fitzco, you make a Fitzco card by pouring about how many drops of blood in each of the 4 quadrants of the card?
I said approximately 250 microliters, 200 to 250, and I don't pour it out of the tube. I use a pipettor.
And how many drops would it take to fill up one of those 250 to 500 microliter quadrants in the card?
I think I said 200 to 250
No, how many drops? 200 to 250.
microliters.
Yes.
And how many drops
How
is
many
that?
drops for each quadrant?
You know, I couldn't tell you.
And these cards are wet when you first drop the blood on them?
Are they wet before I drop the blood on them?
No, after.
Well, if blood's wet, obviously it's going to be wet after you drop the blood on the card.
Right. And in handling those cards, one must protect against the danger of cross-contamination with reference blood.
Yes.
Now, is it part of your training that evidence samples and known exemplars or reference samples be extracted at different times and/or locations?
Sustained.
Have you ever heard the expression that evidence samples and known exemplars be extracted at different times and/or locations?
Once again, my whole practice and procedure allows for every evidence item to be handled separately from another. So it's always happening at a separate time and place. I make sure that none of my evidence is opened up simultaneously. Once again, I open up an item of evidence, I work on that. After I'm done, I close that off and make sure it's away and in no way allowing the opportunity for that to contaminate with anything else. And then I go on to the next item.
Mr. Yamauchi, my question to you was not for you to repeat again, but my question was, have you ever heard the phrase that evidence samples and known exemplars be extracted at different times and/or locations? Have you ever heard that?
Yes, and once again, my
The
protocol
answer is yes.
addresses that.
Yes, the answer is yes, right?
That's what I said, yes.
Thank you. And that is, in fact, a phrase that is in Section 25 of your protocol.
Well, I could take your word for it, or you could show it to me.
Well, first, does it ring a bell with you as an important phrase or admonition?
It sounds familiar, yes.
All right. Show you this document. Call your attention to the last paragraph there. Does that refresh your recollection as to what your protocol contains?
Yes,
Do you rely on that section, that paragraph that's contained in section 25 of your protocol?
yes,
That's under the section of Quality Assurance Program.
yes,
And this section says, to assure that no contamination occurs between known samples and evidentiary samples in a case, the exemplars and evidentiary samples are extracted at different times and/or locations, right?
yes.
Now, first of all, let's get some phrases down. Do you take it to mean that known samples and exemplars would refer to a suspect's reference sample?
Yes.
Now, do you interpret this section of your protocol to permit you to do an extraction of the defendant's reference sample in the same run as evidentiary samples?
Yes, and that's the whole idea behind the precautions that I take, to make sure that I don't open up more than one evidence item at the same time, and so on and so forth with the tubes that are being transferred from one extraction into the amplification tube. These are not allowing any more than one tube to be open at a time.
Now,
And that's the reason why I do it that way, to address that particular issue.
you think that when you're handling a series of tubes that contain evidence samples and one that contains the defendant's reference samples in one run, that you are complying with that section of the protocol?
Objection, that's argumentative.
Sustained. Rephrase this question.
Let's assume, as you have stated, that you're opening each of the tubes that contains the samples and closing them one after another.
I only open one at a time.
You open one at a time. Let's assume that, okay?
Okay?
Do you interpret your protocol as permitting you to do extractions with this series of tubes, all right, in one extraction session, including the defendant's reference sample and evidentiary specimens, as long as you do them one at a time?
Provided the strict precautions that I use in handling my evidence is taken into consideration, that's all right.
So you interpret the phrase at different locations and/or times in a way that doesn't include a situation such as this case, where you handled Mr. Simpson's reference, you extracted Mr. Simpson's reference sample on the morning of June 14th in the same series where you did the Bundy samples.
Objection's vague, compound, argumentative.
Sustained.
Let me try it this way. On the morning of June 14th, you did an extraction on Mr. Simpson's reference sample.
Yes,
On the morning of June 14th, you did an extraction on the Bundy samples.
yes,
That was in the series of 23 tubes that you were doing in one day.
yes,
And you did those extractions in the serology laboratory.
yes,
And you did it in your hood.
part of the time.
And the location was either your hood or your desk right next to the hood where you were doing these extractions.
My workstation and the hood, yes.
That was the location.
Locations,
And the time that it took you to do the extraction on these 23 tubes was how long?
it's approximately an hour and a half that process would take place over.
And as far as you're concerned, your protocol says it's perfectly all right to handle Mr. Simpson's reference tubes along with those 23 samples in that location during that time period. That's perfectly fine.
Sure, provided you take the precautions that I take.
Did you hear Dr. Cotton testify as to the precaution that she takes in terms of extracting reference samples separate from other extractions up until the amplification phase, and I'm referring to page 27305 of Dr. Cotton's testimony.
Objection, still hearsay, beyond the scope, Your Honor.
Sustained.
Are you familiar with the practices of other laboratories in terms of extracting evidence samples and defendant's reference samples?
I'm not familiar with other people's protocols and procedures. I just know that we have ours, and it's got a lot of basis back to the Roche user guide.
In terms of your training, did you investigate the methods used by other laboratories in terms of extracting reference samples and evidentiary samples?
Did I investigate other people's protocols and procedures as to that?
Yes.
No, I don't think so.
You said you have some recollection of the CACLD studies. Does that recollection include anything about how a false positive occurred in terms of extracting a suspect's reference sample at the same time as evidentiary specimens?
Objection, hearsay, beyond the scope.
Sustained.
Now, before discussing the way you handled Mr. Simpson's reference tube and evidentiary specimens in the evidence processing room on the morning of June 14th, I'd like to ask you a few questions about your note-keeping practices. Have you taken a look at the way notes are prepared at the Department of Justice?
I haven't seen their notes.
Did you see any of the testimony with respect to note-taking from Gary Sims or Renee Montgomery?
Objection, also hearsay, beyond the scope.
Overruled. He can say whether or not he saw that.
No, I don't recall.
Do you believe it's important that notes are detailed with respect to the order in which samples are handled? Laboratory notes.
Could you be more specific?
I'll try. Do you think that laboratory notes should be specific as to the order in which the analyst handles samples?
You mean write out what time or everything that you handle each sample?
Well, let's just start with order and not with specific time. Should your notes reflect the order in which you handled samples and performed analysis on samples?
Objection, that's compound.
Start with
Sustained.
ordered samples, handled samples. Should they reflect the order in which you handled samples?
Notes, the reason why anybody takes notes is to ensure that,
Move to strike as unresponsive. My question is simply this.
Do you understand the question, sir? Is it important to note the order in which samples are handled?
I would say that's important, but it's not the most critical issue of note-taking.
Is that something that you do in your notes? In terms, do you list the order in which you handle samples?
Well, in my descriptive notes, it comes out that way because obviously I'm working on one item, and so I've got to describe that, and so on and so forth down the line.
And when you're referring to your descriptive notes, would that include the pages that you made out on June 14th on your serology item description sheets?
Yes, that would be what I'm referring to.
And how many pages do you have referring to your handling of samples on the morning of June 14th and June 15th? These serology item description notes. Do you have a total of 5 pages, sir?
Yes.
All right. Are they numbered in any particular order?
No, they're not.
Here, I'd like to ask that these 5 pages be marked as defendants next in order. 1185. Now, I show you these serology item description notes, the 5 pages, and ask you to look at them and tell me if I have them in the order in which you wrote them.
No, I don't believe so.
All right? Would you please put them in the order in which you wrote them and mark the first page as 1 and go through 5? Now, Mr. Yamauchi, do you think it's good laboratory practice not to note, withdraw. Do you think it's good laboratory practice not to write contemporaneously the number on your note pages?
On descriptive notes, no, I don't think it's necessary.
How do you know, sitting here today, which of these you wrote in what order?
I told you that's the way I believe it to be, to the best, and that's to the best of my recollection.
Now, did you figure this out, the order, in terms of how you wanted to, withdrawn? Did you number these pages in a way that would be consistent with the reconstruction of events that you think would be good for your testimony?
Objection, that's argumentative.
Sustained. Sustained.
Do you have some concern, Mr. Yamauchi, that your analysis of the glove, your sampling from the glove, could have occurred between 9 and 10 o'clock that morning?
Do I have some concern?
Yeah.
Well, I don't have notes as to what time I sampled that.
You don't, do you?
No, I don't.
And you testified on direct examination that you think it happened sometime in the morning, maybe in the afternoon.
Well, if you're reading from an official transcript and that's what I said, then yeah, that sounds about right, approximately.
Mr. Yamauchi, could you have analyzed cut samples from the glove between 9 and 10 o'clock that morning?
Well, according to my notes, I was sampling the other swatches, so I don't think that's very likely. I would have been working on that.
Well, your notes indicate that you sampled the Bundy blood drops between 10 and 11,
Yes.
and that you sampled the 2 exemplars from Miss Nicole Brown Simpson and Ronald Goldman between 11 and 11:20.
Well, they were, you mean the samples that were taken at the scene at that point to act in lieu of having the actual exemplars? Yes.
And you had a conversation that morning with Mr. Matheson and Mr. Fung at around 7:30, 8 o'clock.
That's not in my notes, but that's approximately, I talked to Greg somewhere in there, or Greg and Dennis.
Have you looked at Mr. Matheson's notes as to what time he recalls the conversation occurring?
No, I haven't seen his notes.
Have you discussed it with him?
Discuss what time I talked to him?
Yeah, when a meeting occurred between you and him that morning.
No.
Now, Your Honor, may I put page 1 of 1185, as he's numbered it on the Elmo?
Yes.
Now, let's start reading your page 1 of 1185 from the top. Harris, could you just move it a little to the left? No, I meant to the right. All right. At the top, you indicate here 117, 115, 114, 113, 112. Now, those are the photo identification numbers for the Bundy swatches, correct?
Yes.
And then you indicate to the right of that from driveway, from walkway, and then you have what do you call it, ditto marks underneath it.
Yes,
And then you have grouped their victim's residence, right?
right.
And that reflects the notes you took on your conversation with Mr. Fung that morning on what he was telling you those samples represented.
Yes,
And then below that, you have 106 and 107, and those reflect the exemplars from Mr. Goldman and Ms. Simpson.
what would at that time be used in place of them, yes,
And one of them indicates off the stump, the other one indicates concrete.
yes,
And then you have next to that these samples, not true exemplars, right?
right.
And then the next thing you wrote is glove, right? Can you read that line to us?
Number 9, glove, and then there's BRN, I think that means brown. Because that's what well, these are my notes, that means brown. Brown glove with red stain, as per Fung, and then in parentheses, via RHD, OJ's cut on left hand, and then underneath.
And
Next
what does that
page.
say underneath?
Next page.
Next page. But the next page that you numbered for me just a minute ago is your drawings of the Bundy swatches, right?
Yes,
And page 3 of what you numbered for me is a diagram of the glove.
yes,
So, Mr. Yamauchi, when you put down glove and then next page under that, were you not referring to the diagram you made of the glove?
you know, that makes good sense. That's probably the order they went in.
So, page 3 is page 2, isn't it?
How could that be?
Overruled. Do you understand the question?
Yeah, if you're talking, referring to the numbers you had me put on the pages, yes, but once again, I don't number my pages.
I understand, but looking at your notes and reconstructing it now, what you labeled as page 3 should be page 2. All
It seems that way, yes.
right, do you mind if I renumber them?
Go right
With
ahead.
permission?
Sure.
Now, turning back to page 1. The next entry down refers to Mr. Simpson's blood vial, the reference to.
Yes,
And indicates what you did underneath that is you wrote down what you saw on the outside of the tube. Is that what you did?
yes, the ones in the quotes.
Yes. And then at the bottom, what appears to be in the bottom right-hand side of, as we're looking at on the screen, you have a line that indicates used about 1 milliliter for swatching, correct?
Yes,
Now, looking at your notes now, Mr. Yamauchi, in terms of the order in which you listed the items, does it not appear that you handled the glove, as your diagram on what we now agree is page 2 indicates, you sampled the glove before you did the Bundy swatches?
yes, that's possible.
All right, I think this is a good place to stop.
All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all my admonitions to you. Do not discuss
Good.
this case amongst
I
yourselves.
didn't hear what happened. So when I left, I was listening I was listening to most of it, but I missed the part where what happened. Did he get disbarred? I mean, did Ito do anything at all?
Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1 o'clock. All right, Mr. Yamauchi, you can step down.
There are not now, nor have there been, nor will there be any plea bargaining discussions in this case. This is a case where there is no plea bargain, will be no plea bargain, and I thought I should make the record clear in that regard. And we've heard all these rumors, and I wanted to put them to rest once and for all. Thank you.
Thank you, Mr. Kerner. All right, let's have the jurors, please. Please be seated. And Mr. Yamauchi, would you resume the witness stand? All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. Mr. Colin Yamauchi is again on the witness stand undergoing cross-examination by Mr. Sheck. Good afternoon again, Mr. Yamauchi. Sir, you were mighty. You were still under oath. Mr. Sheck, you may conclude your cross-examination.
Thank you, Your Honor. Good afternoon, ladies and gentlemen of the jury. Good afternoon, Mr. Yamauchi.
Good afternoon.
Now, we were discussing, before we took our lunch break, notes. And would you agree that there is an important scientific reason that one makes lab notes that are detailed?
Important scientific reason? Okay, you're going to have to explain and be more specific about what you mean by detailed.
Well, do you believe that it is important for purposes of another scientist looking at your notes and trying to evaluate exactly what you did and how you did it, that your notes be detailed as to what procedures you performed and the order in which you did them?
Oh, well.
We have protocols and procedures manuals that state and explain exactly how we operate and what conditions we use and everything like that's available. Notes are taken to aid in recollection and to help an analyst recall and remember important points that are happening through the examination process.
So are you saying, sir, that you have a protocol in place and there's no need to take detailed notes as to what you did and the order in which you did it because one can just simply assume that you followed the protocol?
Sustain.
Well, in your answer, you just indicated that did you indicate, sir, that it's not important to take detailed notes as to what you did and the order in which you did it because one can just rely on the assumption that you followed everything that's in your protocol?
Oh, well.
Well, sure, the protocol is there to represent what we do and the manner in which we do it. There are guidelines set up so that the analyst has a way and a reference to know the proper techniques. That's what that's for.
Well, aren't there many important issues of evidence handling that are not addressed in your protocol?
It's fake.
Are there important issues of evidence handling that are not addressed in your protocol?
You'd have to be more specific.
Well, the evidence handling section of your protocol is 2 pages long. Isn't it?
Well, you could show it to me, otherwise I'd have to take your word for it.
Would you like to see it?
Well, if you're going to ask me about it, yes, please.
No problem.
Okay.
Section 4 of your protocol is entitled Evidence Handling.
Okay.
Is that right?
Just that's what it says there.
Well, Mr. Yamauchi, you take a look at it and you satisfy yourself. Don't take my word for anything. You look at it. Does that look familiar to you?
Yes.
Is that the section 4 of your protocol that deals with evidence handling?
If this is a copy from our protocols and procedures manual, I'll take your word for it.
All right, proceed.
Now, Mr. Yamauchi, your section on evidence handling doesn't discuss how swatches, bloodstained swatches, ought to be handled in the evidence processing room when they're collected.
Oh, well.
Well, I'd have to read through this thing again or refresh myself completely, but what you're talking about doesn't sound like it's a complete issue for our unit. It sounds like it's an issue that has to do with processing of evidence that would be associated with the crime scene investigation.
So the DNA unit has nothing to do with the way that blood-stained evidence is collected at a crime scene, dried, and packaged in the evidence processing room.
Objection, that's argumentative.
Sustained.
Your Honor, this is the PCR report.
Sustained.
Mr. Yamauchi, did I understand your answer to the last question correctly? That the evidence, that the procedures used in handling blood swatches from the point of their collection to their drying in the evidence processing room and their packaging in coin envelopes and bindles in the evidence processing room has no relationship or is not covered under the responsibilities of the DNA unit?
Objection is compound, it's argumentative.
Overruled.
No, actually, they're two separate issues.
So from the point of view, from your point of view, as an analyst in the DNA unit, the collection, drying, and packaging of bloodstains is not, for purposes of DNA, stains are going to be used for DNA testing, is not part of your responsibility.
Objection is argumentative, this states is testimony.
Sustained. Phrase the question. Do you need to be there with this exhibit any
Well,
longer?
I will be in a second, yes.
All right.
yes, I'm beginning to-
My only concern is you're standing between juror number 7 and the
I'm
witness.
sorry. I'm sorry. Thank you very much, Your Honor.
All right.
Still experimenting with how to configure myself in this courtroom.
All right, rest witness.
Mr. Yamauchi, when you and Ms. Riley and others were setting up your DNA unit, you did not regard it as part of your responsibility to monitor the methods that were used for the collection and packaging and drying of bloodstain evidence that would be tested in your DNA unit.
Objection is argumentative, assumes facts and evidence.
Sustained.
Did you regard it as part of your responsibility, you meaning the DNA unit, to review and monitor the procedures that were used for the collection, drying, and packaging of blood swatches that would be subjected to DNA testing?
That's the responsibility of the trace unit, and they would be open to any advice that we'd give them. As far as the handling or implementation of any newer protocols and procedures in their end of the laboratory, that's kind of out of my hands. Erin Riley has done training where she's explained handling of evidence and collection, but personally, no, I haven't been involved in that directly.
Was it part of your training? Withdraw. Did the issue arise in your training that the collection and handling of biological evidence before the formal DNA testing starts can result in cross-contamination of samples?
Well, yeah, of course that's possible, but I don't think it's probable.
Mr. Check, why don't you turn the podium to face the witness, please?
Now, in the evidence handling section of your protocol, is there anything in there about how to handle a suspect's reference to?
Objection beyond the scope.
Overruled.
That's not an issue that this particular area is set up to address.
Is there any section in your DNA protocol that lays out procedures for handling a suspect's reference tube during the process of examining and cutting specimens?
It's beyond the scope.
Overruled.
I'm really not sure if there is. specifically addressing that issue in the detail that you described.
So in terms of how you handled the reference sample of Mr. Simpson in relation to the other crime scene specimens on the morning of June 14th, we cannot get any assistance from the protocol.
Sustained.
Can we get any assistance from the protocol in terms of the procedures that are supposed to be used in handling a reference sample and crime scene specimens?
Objection, that misstates his testimony.
Yes, if we could.
Overruled.
Quite possibly, there could be something that alludes to what you're getting at, but specifically what you're talking about, I'd have to go through and review the notes and that protocol and dig through it.
But as you sit here today, to the best of your knowledge, there's nothing you can recall here that specifically lays out how a suspect's reference sample is supposed to be handled in the evidence processing room when you're cutting crime scene specimens.
Well, as you can see, it's a long protocol. I can't just pull it out of the air. I'd have to go look through it.
Well, can you suggest any section other than the evidence handling section where you would expect to find it?
With that specific detail, what you just described, no, I don't think so.
So in terms of the details of how you handled Mr. Simpson's reference sample and the crime scene specimens on the morning of June 14th, would it be fair to say that the written record we would have to rely upon are your notes?
At this point, yes.
And you mentioned just a second ago that one of the purposes of notes is to aid in the recollection by an analyst when you come and you talk to a jury about what you did and when you did it.
Not so much when I did it, but what I did. And basically, it speaks for itself. We do things in normal, the same fashion, over and over again. And we'll take notes if there's anything that's out of the ordinary or that would be needed to refresh your recollection. It's not something that's overly detailed, and it's not something that you just scribble a few lines on either. Because quite obviously, if you're taking notes, you're not working, and if you're working, you're not taking notes. So we have to take a good balance of both in order to get done what we're intending to accomplish. And that's, in the end, to have something to refer back to in case something becomes an issue and say, yes, I have that in my notes. I can recollect that now.
In
That's
the
what it's
court-
all about.
I'm sorry, you finished, sir?
Yes.
In the course of your training, did you consult with other laboratories to see what procedures they used in terms of note-keeping?
No.
Have you done many cases since June 14th and 15th of 1994?
Not many.
How many samples do you think you've processed, that is, in the evidence processing room, since June 14th and 15th of 1994?
Relevant beyond the scope.
Overruled.
I haven't processed any samples in the evidence processing room since then.
You have not.
No.
Have you processed them in the serology lab?
Yes.
All right. And how many do you think you've processed in the serology lab?
Overruled.
I'd have to go back and check the records to be sure.
Think it would be 100 or more?
Possibly.
And you could not remember, without the aid of notes, what you did to those specimens and the order in which you did it.
It's argumented. Rephrase the question.
Can you remember what you did with those over 100 specimens since June 15th? What you did and the order in which you did it without notes?
You're asking me in general or in great detail? Because in great detail, yes, I would like to refer to my notes, but in general, I know I would have extracted them and went about the normal procedures that I do for the PCR DQ alpha process.
Well, is every case the same?
Sustained.
Did you not testify on direct that it is not your custom or practice to prepare detailed notes on items that you sample?
I'd have to see that in its full context.
Did you tell us on direct examination, if you recall, that you take general approximations? That's how you described your note-taking procedure. Cut your note-taking custom and practice.
Insurance bank, it just needs to Simpson.
Overruled.
When I describe certain items, yes, I do take approximations.
Now, referring to June 14th and your notes of June 14th in the morning, your notes do not indicate when you received Mr. Simpson's reference to them, do they?
I don't believe so, but let me check. I have the date that I received it as the 14th of June, but not the time.
So, in terms of time, you do not have, your notes do not indicate when you received Mr. Simpson's reference to. True?
That's true.
And they do not indicate when you prepared that Fitzco card.
No, there's no time on that.
And they do not, your notes do not indicate whether you created the Fitzco card before or after you did cuttings on the glove.
No, it's not indicated.
And your notes do not indicate whether you created the Fitzco card before, after, or during your cutting of the Bundy swatches.
No, they don't indicate that.
Mr. Yamauchi, is your memory improving about how you handled Mr. Simpson's reference sample on the morning of June 14th?
Sustained.
Has your memory been improving since August of 1994? I'm sorry, August 19, yes, it's August of 1994. About how you handled Mr. Simpson's reference to it.
Well, in certain areas, it would depend on what things I would have to spark my recollection.
Well, in August of 1994, you gave some brief testimony concerning your handling of Mr. Simpson's reference to and the crime scene specimens.
Okay,
Is that true?
sounds familiar, yes.
You reviewed that testimony before you came here.
Still, that's many pages, and that's a while ago, too. If you got specific areas, please show them to me. I'd like to see them, and then I'll answer questions about them.
In August of 1994, you were not sure if you received Mr. Simpson's reference sample before or after you received the crime scene samples.
Sustained.
I'm asking you.
Questions not properly formed, counsel.
In August of 1994, were you sure if you received Mr. Simpson's reference sample before or after you received the crime scene samples?
Overruled.
I'm sorry, one more time, please.
Sure. In August, were you sure if you had received Mr. Simpson's reference sample before or after you received the crime scene samples?
I would have just, at that time, probably been going off of my notes. Overall, that's a closer date to the time when it actually happened, so maybe my recollection was a little bit better. But unless I know specifically what you're referring to, I really can't be of much help.
Well, what I'm referring to is, can you remember whether you received Mr. Simpson's reference sample before or after you received the crime scene samples? That's what I'm referring to.
Ask and answer.
Overruled.
You mean now, based upon my notes, or you're trying to make me remember what I remembered back then? That's not easy to do.
Mr. Yamauchi, I'm interested in what you can remember now from your own independent recollection as you sit here today and you testify to this jury under oath. Do you know whether you received Mr. Simpson's reference sample before or after you received the crime scene samples, the Bundy swatches and the glove?
I believe I did, yes.
Which, before or after?
Before.
Before. You sure of that now?
Well, judging by my notes and the order of things that are going on, I would say that's the time when I received it.
You received it before,
Yes.
okay? And and those are the same notes that you're looking at now that we just went over with the jury. That's 1185, right? page 1. Put that up.
Yes.
Same set of notes that you were looking at when you testified in August.
Yes, should be.
And isn't it true that the best you could remember in August is that it all happened at approximately the same time? That is, that you received the crime scene samples and the blood vial at approximately the same time, but you weren't sure which you received before and which you received after.
Sustained.
In August, wasn't the best you could remember is that it all happened at approximately the same time?
Is that what I said?
Is that what you said? Is that the best you could remember in August?
Well, you know, if you could allow me to review that part of my transcript, I'd probably be better off answering your questions.
Sure. I'm now reading from page 620 of the Griffin hearing. Where you asked these questions, did you give these answers?
He's asked for an opportunity to review the testimony.
I'll not read it.
Read it to him.
Question. Yes, on page 620, line number 7.
Mr. Scheck.
Question. So then you received a reference sample on June 14th. Answer, yes. And did you receive that before or after you received the crime scene samples? Answer, I'm not sure. Question, you don't know. Answer, indicates in the record no audible response. Question, was it around the same time? Answer, approximately, yeah. Where you asked those questions, did you give those answers?
Yes, that sounds reasonable.
So in August of 1994, about 2.5 months after you actually were in the evidence processing room dealing with these samples, you weren't sure when you received the crime scene samples in relation to Mr. Simpson's reference sample, right?
Full roll.
Yes, and after we've been through this carefully and I've looked through my notes more, that's why now I feel, but I've still stated, there's no time on here, so I don't know for sure. But based upon my notes, I have a good feeling that that's when it happened, before I received the other evidence.
These notes that we're looking at, 1185, page 1, same notes you were looking at in August, right?
That's correct.
But now, on direct examination, you specifically remembered that you received Mr. Simpson's reference tube after a conversation with Dennis Fung. Right?
That's right. Since that time, I've had chances to look over my notes more carefully and try to piece together that issue.
Same note, same piece of paper.
That and the rest of my notes,
The other 4 pages?
yes.
Do the other 4 pages say anything about Mr. Simpson's reference sample?
No, they don't.
And you told us on direct examination that you now specifically remember that you went to the end of the table in the evidence processing room by the garage door.
Sustained.
Did you go to the end of the table in the evidence processing room by the garage door with Mr. Simpson's reference tube?
Yes, I recall making the blood swatch card in that area.
And that's where, it was in that area that you now specifically recall you made the blood swatch card.
Not specifically, but generally speaking, it was on that end of the room.
All right? And you now can tell us that you made the blood swatch card before you examined the glove.
Judging by the continuity of my notes and the next page entrance here that you pointed out, I would say, yeah, that's the most likely scenario.
And you now can tell us that you specifically recall making the Fitzgo card with Mr. Simpson's reference tube before you did cuttings of the Bundy blood swatches.
Yes, that goes in line with the continuity.
And you now can specifically recall that you were concerned about wind currents when you were at the end of the table in the evidence processing room handling the reference sample.
Wind currents?
Yeah, didn't you say something about that on direct?
I'm not sure. I don't recall that.
And you now specifically recall an independent recollection, not what you usually do, but you independently recall that you pipetted about 1 milliliter out in your left hand.
I described the procedure that I usually take when I make those cards, and that's to pipette 1 ml of blood out of the tube, the reference tube, and into the pipetter.
Were you testifying on direct examination about what you usually do or what you independently recall doing on the morning of June 14th?
Sustained.
You just said to this jury, when I asked you about pipetting with your left hand, that you were testifying that's what you usually do. Just say that?
Yes, and to answer your question, it's a little of both.
Well, I'd like you to direct your attention to what you independently remember from the morning of June 14th, as opposed to what you think you would have done. Okay?
Overruled. Ask a question.
Do you have an independent recollection of walking to the end of that table, the evidence processing room near the garage door?
I have an independent recollection of making that swatch card on somewhere at that end of the room.
Now, on direct, you indicated that you walked around to the end of the table, didn't you?
You're going to have to be more specific about that.
Do you have an independent recollection that you didn't hold the tube in your right hand when you were pipetting with your left, but you put it on a stand?
Yes.
An independent recollection of that.
I would have to put it on a stand.
When you say you have to put it on a stand, as opposed to holding it in your right hand, are you telling us that's what you would have done, or that's what you independently recall you did?
No, okay, I don't remember specifically, step by step, exactly what I did, and that's why I go back to my normal standard practice and procedures.
But when you testified on direct examination, weren't you telling this jury that you had an independent recollection of exactly what steps you took in handling Mr. Simpson's reference sample on the morning of June 14th?
Objection, it's argument.
Sustain.
Mr. Harmon asked you very, very specifically, didn't he? Did you change your gloves between making the Fisco card with Mr. Simpson's reference sample and then moving on to cut the Bundy swatches? Do you recall that?
Yes, that sounds familiar.
And do you recall when he asked you that question, he asked you if you had an independent recollection that you actually changed your gloves. Do you recall that?
I'd have to see the transcripts. I'm not sure I recall that.
Well, then let's get to what you can recall and what you can't. Do you have an independent recollection as you sit here today that you changed your gloves after handling Mr. Simpson's reference sample and then moving on to cut specimens?
Of course I don't remember independently every specific detail, but once again, my procedure and practice is when I'm doing those blood tubes, I change my gloves.
My question is, do you have an independent recollection that you actually changed your gloves on the morning of June 14th?
Overruled.
Yes, I do.
You do.
Yes.
Is your memory of those events, handling Mr. Simpson's blood vial, improving since August?
Well, the way you're making me think about it right now, I had to remember back to what I did with those gloves. And now I recall I had those gloves in my hand, they had blood on them. I would have to get rid of them, and I couldn't get rid of them right in that area at that time. I had to go around and either put them into the receptacle behind me or take it back to serology to dispose of those gloves. And somehow or another, that's what reminds me of taking off my gloves at that point.
Just occurred to you as we're talking right now.
Yeah, you're bringing me back to that time and place where I was doing that. And yes, it helped my recollection.
Well, on direct examination, didn't Mr. Harmon ask you about a biohazard bag in the evidence processing room?
He might have.
And that's where you put your gloves? Didn't that come out in the questioning on direct?
Objection, that misstates the testimony.
Sustain. Rephrase the question.
Mr. Yamauchi, in preparing for your testimony in this case, did it come to your attention that mishandling Mr. Simpson's reference sample in relation to the crime scene specimens could be a very significant error?
Sustained.
What?
Rephrase the question.
In your discussions, in preparation for your testimony, did it come to your attention that mishandling Mr. Simpson's reference tube in relation to the other crime scene specimens on the morning of June 14th would be a very serious error?
Sustained.
Did anybody discuss with you whether mishandling Mr. Simpson's reference tube on the morning of June 14th in relation to other crime scene specimens could be considered a serious error?
Mishandling any evidence item is not a good thing. It's common sense.
In your preparation discussions, was it not brought to your attention that mishandling a reference tube is more serious than mishandling other specimens?
Sustained.
Was it brought to your attention that mishandling a reference tube could be considered more serious than mishandling other specimens?
Well, given any scenario, of course it could be, or maybe it wouldn't be. The bottom line is you don't want to mishandle any evidence or reference sample.
Mr. Yamauchi, in our short discussion here, did you not say that you have an independent recollection now that blood got on your hands when you opened Mr. Simpson's reference tube? Did you just say that?
Sustained.
Did you get blood on your gloves when you opened Mr. Simpson's reference tube?
Yes, soaked through the paper.
Do you remember that now?
Yes, I do.
In other words, didn't you testify before that when you opened the tube, you did it with a chem wipe?
Yes, and the blood soaks through the chem wipe.
So you're now saying that you have an independent recollection that the blood soaked through the chem wipe.
Along the tip edges, yeah.
And that's something that you didn't even recall when you were asked about this on direct examination.
Was I asked that specifically?
Well, do you recall being asked how you handled Mr. Simpson's reference tube on direct examination and giving a description?
Yes, I recall describing that process.
And when you gave that description, did you include the fact that the blood went right through the chem wipe and got your gloves dirty?
No, I don't believe so.
Because, in other words, it's in our discussion here on cross-examination, this came to you for the first time.
When you started talking in that much detail and you asked these specific questions, giving it to the best of my recollection.
Do you feel confident, Mr. Yamauchi, that your recollection of how you handled Mr. Simpson's reference sample on the morning of June 14th is not affected by how you think you're supposed to answer these questions?
Sustained.
Do you now recall that you put the Fitzco card 10 to 15 feet away from the specimens, the Bundy specimens?
I think I said that on direct.
Yeah. Is that what you remember now?
Yes.
Specifically recall that.
Yes.
But in August, 2 months afterwards, you weren't even sure whether you got Mr. Simpson's reference tube before or after you received the crime scene specimens. Isn't that true?
Actually, it misstates the testimony.
Sustained.
Now, this morning, in reviewing your notes a little bit more carefully, or withdrawn, I shouldn't say that, in reviewing your notes, you agreed that you could have cut samples from the glove before you cut swatches from the Bundy samples.
Yes.
And you began, we know from your notes, and I'm turning to page, well, we renumbered page 3, but I know I said, Your Honor, let the record reflect that when I renumbered the pages, I put a cross through and I initialed it.
Noted. Thank you.
No, don't you start in. We're up to here on you today. We've had more than we can handle of your Don't swear. Don't swear. Don't swear. Don't swear right now. Don't swear right now because you're on camera and you have a microphone that's way over there. All right, guys. We need to go pick some flowers or watch a butterfly or something. So we're going to do. Thank you so much for coming out. I appreciate it. I appreciate it. And I shall see you all tomorrow. Tomorrow morning, bright and early. Have a great day, guys. Bye.